That was before the defense testimony.
Don't get brazen with me.
If they were talking about your children, you would definitely notice.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender. And these people are upset about specific things that have
Quick question for you watching. Do you think judges should keep their cool no matter what? Or do you think attorneys sometimes cross the line so badly that a judge snapping is justified? Let me know in the comments.
That have gone on from that table, like shooting the middle finger up at this court and laughing and joking. Miss McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. I
didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper. Before this court to allow that kind of testimony is also improper. I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it. Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused.
And here's where it gets really intense. The death penalty versus life. Remember, legally speaking, victim impact statements can't cross into unfairly swaying the jury. But as you'll see next, that line gets pushed to the breaking point.
You're excused. You need to go sit in the back with your chief public defender.
He's the public defender.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
The work week can be stressful, and deciding what to eat can just add to that stress. Well, HelloFresh can take the stress out of planning and cooking your meals. HelloFresh delivers meal kits straight to your door. It's 25% cheaper than takeout and a whole lot healthier. Here's how it works. Choose your recipes online and you'll get fresh, pre-portioned ingredients that will help you cook quickly. There are dozens of recipes to choose from, so if you have picky eaters, there's no problem. The cook time is also quick, just 15 minutes. If your family is anything like mine, they're probably hungry all of the time, so you can add snacks, sides, and more to your order. I've tried HelloFresh and it really takes the stress out of dinner time. And you can try HelloFresh with a discount. Who doesn't love a discount? Go to www.hellofresh.com/50sidebar. Use the code 50sidebar for 50% off plus 15.
Whoa, did you catch that? A sitting judge accusing defense counsel of dragging her children into the trial. That's a massive accusation. And if true, it goes way beyond standard courtroom decorum.
15% off the next 2 months.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon.
So, not only did this trial end without the death penalty, sparking outrage among many, but the judge herself ended up facing discipline. This case wasn't just about the defendant. It put the entire courtroom on trial in the court of public opinion.
He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that.
No, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff will...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
This court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. He took his shirt off as well. I'm also told that he is threatening to throw and break items.
Threw people off the loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
it.
Stop
it. You're a public servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it. I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. You don't got to explain nothing to me. That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand.
I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how it said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one ear that work, and I heard that.
This is to benefit you so that you
not.
understand
Ain't none
your
of this to benefit me, so let's
has
be clear
a prior
about that.
record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice. This is the alleged record of ableist...
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value. This document. One more interruption and you're going to be removed to the next courtroom. That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your Honor, I believe he has 7 prior criminal convictions via OWI second criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly,
it makes me scared.
Next two things are just follow-ups on other business that we held a little earlier.
That right there is a prosecutor getting scolded hard. Question for you. Should prosecutors be allowed to push boundaries to expose inconsistencies? Or is it dangerous when they ignore a judge's ruling? Think about the stakes. One bad move could overturn an entire trial.
Mr. Menendez, good morning, sir. You were supposed to buy lunch for your colleagues. Have you done that as of yet? You were supposed to have done that by March the 17th. Did you go to, I told you Jason's Deli? Did you satisfy that prong of your contempt yet?
I don't believe I was, Your Honor.
You were held in contempt, young man. And if you want to revisit that again, we can certainly open it up. I just want you to pick a date.
Yeah. Whatever date is looking for Masons. That works for me, Judge. And also, I never saw the contempt order. I misinterpreted it.
Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt. To the next matter, Mr. Johnson, how are we doing on that paper? I mean, the importance of professionalism. Yours is due by the 28th of April. I'm just checking, I'm just clocking. So we on track? Well, your better half said she's not writing it for you either, because that wasn't offered to you. You already asked me, could I pay the $1,000? I told you no. Well, I know you would, but that's not what's on the table. 28, yes, at noon. Or you do 20 days. It's 17-page paper on the importance of professionalism in the legal field and treating one's opponents with civility. Paper is to be published quality in APA format and at least 10 primary and 10 secondary sources.
Mr. Brooms has testified. He's actually been called by the state on numerous occasions, over several hundred homicide cases, and testified to what constitutes a threat.
Your Honor, I would like the defense to name me one case where Detective Burns has taken the stand and stated to a jury that he believes something was a threat to an individual. Name one.
Hang on, so would I. Well, a case number that occurred in Milwaukee County.
Well, the state hasn't asked for any type of addendum to Mr. Brooms.
Counsel, I'm asking.
Well, Mr. Brooms is not here right now, but
hang on, Counsel. You just represented that he's testified hundreds of times in this court. For me, this court means me. I don't care what happens in front of other judges. I don't care what happens down the hall. I'm presiding over this case. I will make the rulings. So as far as I'm aware, he's never testified in front of me. And I don't recall ever hearing testimony along the lines of what you just indicated. So unless you have a case number that I can look up in Milwaukee County, but particularly one that was in front of this judge, then forget it. You guys cannot just make blanket allegations from the defense without supporting it. You didn't support it in writing, and now it's not being supported on the record. That was a valid request. Name a case now, or we're moving on.
Mr. Brooms can testify to the cases that he testified in.
Name a case now.
We don't have that information.
And he's not testifying.
I mean, he's testified in several cases.
Counsel, he's done it with other judges. Argument does not work with me. Mr. Huebner knows that. Mr. Ahmad should know that. I don't care what other judges have ruled. Period.
You don't know if other item had been moved from one place and put in another place.
Objection, Your Honor. There is absolutely no evidence that anything was moved.
That's right. There's no evidence of that. Don't imply something, Counsel, that there is no evidence of. None. There's been no evidence introduced in this case by any witness that is even close to that. That assumes facts, not in evidence. Sustained. Move on to a relevant question. Don't imply things that have not occurred and are not in evidence. Move on.
I'm not an expert, and so what one does isn't what we're here to show. We're here to show what he did.
Right, but that's different. No, Attorney Pattis. How many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. I don't know how I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to find an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now. But if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you nicely. I'm literally almost begging you. I have no recourse but to do that. I'll start with Attorney Maddie. What do I need to do to stop the comments and the call? Just tell me what I need to do. Do I need to hold one of you in contempt? Attorney Pattis? I'm not going to have the comments anymore. I'm not going to have it. I'm not going to have it.
Do you expect me to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not going to happen.
6. Life sentences plus 700 years. That's basically the justice system saying, you are never, ever walking free again. And honestly, after watching Brooks argue with a judge like that, it almost felt inevitable.